and I'm not going to be able to see my control panel anymore, Lynn. I'm going to turn that over to you completely. So you in charge. I'm going to go into my full screen mode so people could see the document a little better. Good evening, everyone. As I've been saying for the last half hour, perhaps 45 minutes, this is Deusdeddy Merced. Today is Wednesday, May 11th, 2016. As I said just a few seconds ago, this webinar is being recorded. In a few minutes, I will be leading this evening's presentation. I will be joined by three of your colleagues, Michael Lazan, Nancy Liederman, and Karen Norlander. Thank you, Michael, Nancy, and Karen for joining me tonight. Lynn Beekman will also be joining the panel. Before we get started with the program, I have to review some items. You might have memorized this by now since we've been saying the same thing for the last few years. But first, the training materials were provided directly to each of you via email. The email included an affirmation form. At various times throughout the webinar, I will display various codes that you must write down on the affirmation form. The codes will not be read out loud. I repeat, the codes will not be read out loud. Right now, you should be seeing, and I'm displaying on the screen, the course code. Please write the course code down on your affirmation. Please write the course code down on your affirmation. I'll leave it up there while I finish my opening remarks. If you do not have your affirmation, as I said earlier, on the control panel, I uploaded the materials for today's webinar. One of those documents is an affirmation form. You can click on that document. The form will download onto your screen and you can print it, and then voila, you have your affirmation. Write the course code down. I will not be reading out loud any of the codes today, so I'll leave that up for a few more minutes. Submission of the affirmation form with the correct codes is required by the New York CLE board and by NYSED for the continued certification as a hearing officer. Please keep in mind, as NYSED has advised you, I believe it was back in 2015, July 2015, only hearing officers who participate in the entire session of the live webinar program would meet the requirement for participation in the update training and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you view the live program for the full 2 hours. Partial participation will not be accepted, and the telephone option is not a substitute for the requirement that you view the live program. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, May 20th, 2016. Again, that date is Friday, May 20th, 2016. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Second, all participants will be muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to hear your thoughts on the discussion as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there's a question dialog box with the wording "Type questions here" or questions. It too will accept comments. I will pause to take questions or comments throughout the 2 hours as time permits. Lynn will interject those questions or comments as appropriate throughout the 2 hours. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through the GoToWebinar application. Let's begin. Course code is up. Going once. Going twice. Gone. Okay. Throughout the past 5 years, Perry, Lynn, and myself have cited OSEP opinions in both our discussions and training materials. OSEP, as many of you know, is the federal agency with primary responsibility for administering the IDEA. It periodically publishes interpretations of the IDEA in the form of memos, dear colleague letters, and policy letters. You all have seen them from time to time, and there are hundreds of them. Not all, however, are applicable to our work, but many are. Unfortunately, they're not easy to find because OSEP does not have a great topical index on its website. And Special Education Connections, which you have access to, does publish them as they are issued, but again, its search engine is not as robust as we would like. We therefore thought that it would be a good idea to put in one place these memos, dear colleague letters, and policy letters that are of interest, specific interest to you as hearing officers. And we plan to update this outline periodically. Eventually, as Lynn reminded me earlier, we will publish these on our website and give you access to the updated outline vis-a-vis the website. In addition, like OSEP, New York State too publishes guidance from time to time. These are interspersed throughout the SED website. SED graciously put together a list of relevant published guidance and provided the URL for each. Those are included in the addendum that I shared with you when I sent the materials on Monday. And if you don't have it and you want to look at it, again, the addendum and the other materials are on the control panel, the GoToWebinar control panel, and you can download it quickly, and you can download it now and print them out and view it. The U.S. the U.S. Supreme Court has said that agencies like OSEP may fill in the blanks when Congress has not directly spoken to the precise question at issue. As such, courts have recognized, including the Second Circuit, that OSEP guidance is entitled to some judicial deference. This said, the written guidance is not binding like, for example, regulations, the IDEA regulations. It does not impose any substantive obligations. It's simply interpretive in nature, which is to say it clarifies aspects of the IDEA and its regulations. Moreover, more often than not, OSEP provides answers to questions courts typically do not address because they're not so significant to be appealed and become an issue in an appellate case. An example of this is whether telephonic testimony is permissible in IDEA hearings. OSEP has a letter on that saying, yes, it's permissible. I want to start, before we get into the specific letters, etc., with a few questions to the panel. First, I'd like to hear from you, Michael, Nancy, Karen. Do you cite to OSEP guidance in your decisions? And when do you find it appropriate to cite to OSEP guidance? Any of you can start.
Well, I can answer if you're hearing me.
We can hear.
Okay. I cite to them rarely, I do cite to them if I don't cite to them on my own. It's not something I bring up on my own. If an attorney cites to them in a post-hearing submission and it's an appropriate kind of cite, I will put that into my opinion. But if I don't find it appropriate, I won't put it into my opinion. I mean, and that's basically it. I'm not that familiar with them. I mean, this is a very useful outline in terms of, increasing familiarity, I believe. But I'm not that familiar with these opinions on my own, so it's only if an attorney actually cites to it for me that I will be using it.
Yeah, and they're hard to find, and some of them might start off with a specific question, and as we're going to hear, the specific question is they provide an interesting answer, but sometimes all the other stuff is more interesting than the answer to the specific question. Michael, Karen?
I can answer that. I do use OSEP memos sometimes when I like the memo and it's useful to make a point. So I'm familiar with a few of the OSEP memos that I think provide a good outline of the law or are generally considered to be persuasive. Some of the OSEP memos are not well known, and some of them are better known. For instance, I believe there's an OSEP memo that says a parent consent to an IEP does not mean the IEP is necessarily one that provides a FAPE. There's another OSEP memo about observation, parent observation of school district classrooms that doesn't allow it, and which may be called into question to an extent with some recent Second Circuit case law. There are a few other ones. There's one about allowing in evidence on the after the first day of hearing, even if it hasn't been disclosed before the first day of hearing. So there are a few OSEP memos in my toolkit that I will pull out if I think that they'll help my decision.
And I'm going to be discussing at least two of the ones that you mentioned. I'm not so familiar with the one about not allowing the observation, but I might have it, and I might, and when we get to the section that I'll discuss it, you'll tell me if that's what you were talking about. I don't read the decision to say that, but I could be wrong in terms of what the letter that you're referring to. Karen? You have to unmute yourself, Karen. Okay. While Karen is figuring out her difficulty.
This is Lynn.
I was going to say, Lynn, do you want to jump in?
Well, I think one of we as hearing officers do a lot on procedural matters based on our discretionary authority. And I don't think there's anybody authority for what we can do in terms of filling in the voids on how these hearings are run than citing the OSEP letter and the comments to the regs. And I know Deestetti has got these things mentioned in the outline, but whenever you get into an area where you have to make what might be a controversial ruling on procedure because there isn't anything in IDEA or New York regs to govern the particular point, I think we are well advised to cite the OSEP letter to anonymous, which I think is about like Deestetti's going to mention it and he'll bring it up. And there are comments in the regs as well with regard to our authority to deal with these areas where neither IDEA nor state law here in New York mentions them, because courts so often are not even aware of the array of OSEP letters or the things that they are in support of. So that, I think, probably would be the #1 best use that most of you could make of an OSEP letter or comments in the regs to support your general discretionary authority. I'm wondering, do any of the members of the panel ever utilize the New York State guidance documents that are referred to in the addendum? Do you ever have occasion to use those, or do the parties cite them to you at any time?
I'll jump in again. Sure, why not? I mean, if there's an issue that that you can't find any authority on, sometimes you can go to the NYSED website and find a Q&A, and you can pull something out of there, and if you think it's reasonable, you can use it. I've used it on a number of different occasions, and I think that, if you disagree with it, you don't necessarily have to follow it. I can remember a decision where I saw something on the NYSED website interpreting a law that I didn't agree with, and so I didn't follow it, and I put it in the decision, and I was then reversed. But I still think I was right.
But
Oh, you put it in the decision, Michael, as opposed to just ignoring it?
Yes. I
and you explained why you were departing from the policy, I presume?
Correct.
Okay.
But I pretty much had to use it because that was the only authority that was out there, and it was the district. It was really a district argument that was being made. And
what basis was the reversal?
Well, I don't know. I'm still not clear on what the basis of the reversal was, but it wasn't clear to me why I was reversed exactly on that point. I think that probably the review officer thought I was being unreasonable in what I was requiring the school district to have done. And that it was, but I just felt that the memo went beyond what the New York State. It was actually an interpretation of New York State law, not the idea New York State special ed law. And I thought that the memo went beyond the New York State special ed law, and I couldn't reconcile it with the New York State special ed law in all good conscience, really. I just thought it was wrong, so I didn't go with it, but I put it in there. But I kind of thought I would end up being reversed. I was, but that's just the way. Sometimes you have to be reversed, I guess.
Yeah, but I mean, listen, your practice of looking at it, interpreting it, and saying, I don't agree, and these are the reasons why I don't agree, is better than not including it at all in the decision. You can rationalize. You can depart from court precedent, et cetera, and you have to explain it. And you hope that someone who's reviewing you down the road agrees with you and say, yes, I agree with this hearing officer. But I think that is, as you've done, it's the better practice, which is if you're going to depart from some policy guidance of either NYSED, OSAP, then you cite to it, you put it right in center in the decision, and make sure that you explain why you're departing from it. And it appears that the state review officer disagreed. It's whether they disagreed regarding your interpretation of the policy or not. It's not clear to me yet, but that's a good practice. Lynn, well, I'm going to continue, but see if we can get Karen back online and see what's going on. I could see that she's still muted, but I don't know what's going on, whether it's...
I'm here.
Oh, good. So do you want to share your thoughts on the questions and issues and comments that you've heard?
Unfortunately, I was off for a minute because I had to get some technical assistance. So
okay.
Really.
No worries.
Okay.
We'll get you on.
I will be very active. I promise.
Don't worry. We'll get you again. Don't worry. No problems.
Dave Steady?
Yes.
This is Lynn again. I'd just like to reaffirm the point that you just made, because I think it's extremely important. if there's an OSEP letter, quite frankly, any non-binding authority out there, but we're talking about OSEP letters at the moment, that is either cited by counsel or that you might find in your own research that is on point, I totally agree with Deisteti's comment that it is better practice to address it and indicate why you are not persuaded by it, even though it should be, presumptively given some deference, but like Michael did, explain why. I've had that come up, and I think it's better to do it and put it right out there and explain it than to ignore it and then have it come up potentially later with the SRO or a court on review, and then they're left hanging there, and you could be more easily reversed, I think. That was it.
By the way,
I have a question. I have a question concerning that, though. My question is, when I was looking through this outline, I noted that there were some of these opinions that were very old. That go back to, I think they went back to the 1980s, if I'm right.
The oldest one is 1979.
Well, there you go. And and I was just wondering. I mean, I don't remember the specific examples, but I did think that would be something to be looking at, because practice changes on, in terms of like on the ground so much in the intervening years. That's a long time ago.
Yeah, and I do address that when I talk about one of the references in the outline is to the 1999 Q&A on IEPs, the comments to the 1999 amendments to the IDEA. They had a nice Q&A, if you recall, for those of you who have been practicing that long, that answered a lot of questions about what needs to go into an IEP, what, in terms of annual goals, etc. And what you will find if you read a lot of these cases, OSEP cross-references some of their own letters going back in time, including some of the comments to prior amendments to the regulations. What obviously you need to do is that the law does change, and you have to cross-check to make sure that that aspect that they talked about, that issue, has not been superseded by a change in the law. But OSEP has no problem with going back and saying, as we said in the 1999 comments, or as we said in letter to John Doe, this rationalization is still good, etc. And you just have to look at it and see whether there has been any intervening events, any intervening letters that supersede the rationalization in the older letter. But the fact that they're old does not necessarily make them stale.
We have a question.
Yeah.
One of the participants out there asked, do you think that these opinion memos should be treated as documentary evidence, which this hearing officer has had happen, or simply cited as legal authority?
That's a good question, and Lynn and I have gone back and forth on that somewhat. I would say that there are, for the most part, interpretive rules by the agency who is charged with monitoring the IDEA. So I would not have any hesitation with citing them as part of any research that I found. I think if there's a question, if you found them while you're doing some research just to prepare for the hearing or even the pre-hearing conference, and there's a question about how it might apply to the facts and circumstances, I might bring it up during the pre-hearing conference. I might bring it up prior to the hearing, give the parties an opportunity to respond. I might give them an opportunity to include it in their closing briefs or written briefs after the hearing has concluded. And I may also, when it comes to the NYSED guidance, that's something where I might, again, if I know that it exists, I may give the parties an opportunity to weigh in as to how it applies to the specific facts and circumstances. As you read OSEP letters, memos, your colleague letters, you'll realize that, they're not as specific as one might want. So there may be instances where it's though they're giving you some guidance, there's still some grayness to what they're saying, and you might want to give the parties an opportunity to just simply weigh in and provide you with their perspective as to how it might apply to the facts and circumstances of your specific case.
How have the panelists, what's been the experience of the panelists in this regard?
I have not come across it, but I would agree with Ducetti that it's something you're citing too, as opposed to documentary evidence that you would want submitted at a hearing, although the issue could be pivotal and could be decided perhaps if there's agreement.
I would agree with that. I mean, it's definitely something I would take judicial notice of, but you want to make sure that all parties have copies of whatever it is you're taking judicial notice of.
I would agree, except that I don't think that I'm not sure everyone has to have copies of it. If it's available, you can cite to it, just like you can cite to a law review article. Also, really, not that I do that, but if it's legal authority, I think that you can cite to it without it. It really shouldn't be in evidence. I think that it's better practice just to use it to treat it as one would treat a case.
Well, if we're discussing it up front, during the hearing, and basically I'm thinking about New York City, where so many of the representatives are not attorneys, and often where they're pro se parents. That's basically what I'm thinking about. I'm not thinking about when all parties are attorneys and capable of doing their own research.
Right, and there's some value to what Nancy says as well, in terms of, like I said earlier, these letters are not easy to find. I mean, if you go to the OSEP website, they have an awful topical index, and they essentially list the letters by years, and they just say letter to such and such, and they don't tell you what that letter is about. And the search engine on Special Ed Connections, which is the only other search engine that would have these letters, because I don't believe you can find these in Westlaw. Correct me if I'm wrong, guys, but I don't believe you can find these in Westlaw or what's the other one, Nexus. They publish them, but finding them in Special Ed Connection can be difficult. I have actually found letters vis-a-vis people who have been around from the beginning of time, meaning IDEA, that they've shared with me because they have a hard copy of it, and you can't even find it on the OSEP website, because OSEP goes back, if I may be missing it by a couple of years, but I think they only publish since 2000 so they only go about 16 years back, and these cases and these letters have been published since the late 70s, 1970s. So they're not all on the website, the OSEP website, and Special Ed Connection doesn't have. I've actually submitted to Special Ed Connection some of the OSEP letters that I've gotten from colleagues, and they then have uploaded them for people to be able to have access to them. So I understand what Nancy's saying. All right, let me move on. I just want to talk quickly about deference. It may be appropriate to defer to an OSEP memo or letter, as we've been talking, where there is ambiguity in the IDEA or its regulations, and OSEP has provided interpretive guidance, which is persuasive. Specifically, the process to decide is simple in my mind. First, you have to ask yourself, is the IDEA and its regulations ambiguous on the precise question at issue? If the answer is no, the IDEA is not ambiguous, then you, as the hearing officer, have to enforce the unambiguous express language in the IDEA or its regulations. If there is ambiguity, then you may defer to the guidance if it is persuasive. And to determine whether it's persuasive or not, you need to just ask yourself three simple questions. Did OSEP thoroughly consider the issue? How valid is its reasoning? And 3, is it consistent with the clear meaning or purpose of the IDEA, its regulations, or legal precedent? If the answer to all 3 of those questions is in the affirmative, then obviously you have a good persuasive piece of authority, interpretive rule from the agency responsible for monitoring IDEA to cite to and use as part of your reasoning or basis for your decision in your case. With that brief background and discussion, I'd like to now turn to reviewing some of the key OSEP memos, dear colleague letters, and policy letters. I plan on focusing on a few more than others, and will follow the order, as I said earlier, in which they are presented in the outline. I'm going to stop from time to time to discuss some key points and to get the panelists to offer their comments. But panelists, if there's something that I gloss over and you want to stop and talk about, please feel free to interrupt me. If there are questions out there, Lynn, that come in and we need to kind of go back to just to a letter that I've moved on from, then we'll just go back. So let's begin.
Hold it. Before you do, it's code time.
Thank you. You're going to be my reminder for that. All right, guys. Code number 2 is going to go up on the screen. Code number 2. Code number 2 is on your screen. Code number 2 is on the screen. Write it down, please. Code number 2. Going once. Going twice. Gone. Okay. OSEP has issued a number of Q&As on a variety of topics, including on IEPs and dispute resolution procedures. These Q&As are updated periodically. The Q&A memo on dispute resolution procedures on page 2, halfway down from the top, was last updated in 2013. It addresses questions that frequently come up with respect to mediation procedures, state complaint procedures, and due process procedures. It's long and it's representative of a more comprehensive guidance document than what OSEP typically issues. Typically, the letters are 2 to 3 pages. On occasion, you'll see one that's about 5 pages, but the Q&As are usually up there in number of pages. This one happens to be approximately about 40-something pages. The Q&As fill in the gaps where IDEA regulations are silent or vague. For example, if you look at paragraph 3 on paragraph 2 on page 3 of the outline, you will note that the guidance says that an IHO's decision on a notice of insufficiency must identify how the complaint is insufficient so that the filing party can amend the due process complaint if appropriate. The language in the regulations, the IDEA regulations, simply says that the IHO must make a determination of whether the due process complaint meets the requirements. There's no mention that the IHO's determination has to include the quote how, or nor does it hint that the filing party has the opportunity to amend. Again, these Q&As kind of fill in those gaps that you might need in order to work the process out in terms of allowing for, in terms of what needs to be included in your notice of insufficiency. Another example of this is on page 4, subparagraph 12, that talks about the 45-day timeline. IDEA and its regulations are silent on what happens to the 45-day timeline at the conclusion of the 30-day resolution period when the resolution meeting has not taken place and neither party has sought the hearing officer's intervention to either start the hearing timeline For example, when the school district fails to convene the meeting within the 15 calendar days, or dismiss the complaint when the parent fails to participate. OSEP says the 45-day timeline begins automatically. That's not in IDEA. That's not in the statute. That's not in the regulations. So these like two little go nuggets you will find in this guidance document, and you will find a lot more in this 40-page document. So if you haven't read this document in terms of some of the issues that might come up during the due process hearing or during mediation or during the resolution process, it's worth a look-see. It's about 40 pages, but it's nicely written, and it gets to the point and cites back to its supporting regulation or statute. Let's move on to letter to anonymous on page 5, which is the letter to anonymous that Lynn was referring to earlier in our discussion. The significance of this letter far exceeds the importance of the specific question that was asked of OSEP. And that question was, must a due process hearing officer permit parents to present testimony by telephone? The answer to the question, as you know, is yes. It's within our discretion to allow telephonic testimony. This is probably one of the most important letters available to you as a hearing officer. It speaks to the expansive discretionary authority of IDEA hearing officers. OSEP notes that you have a responsibility to make sure that each party has a meaningful opportunity to exercise their due process rights and to make sure that the hearing effectively serves to resolve the dispute. But there's significantly more to this letter. OSEP also says that decisions regarding the conduct of due process hearings are left to the discretion of the hearing officer, subject to appellate review. This theme of extensive discretionary authority of IDEA hearing officers can be found in many other OSEP letters, as well as the comments to the IDEA regulations. For example, at the bottom of page C in subparagraph C, OSEP, in a comment to the regulations, again says that the hearing officer enjoys considerable discretion in addressing pre-hearing matters. Similar expansive discretionary authority language is used in letters cited on page 6 and 7. I'm pointing this all out because in the past 5 years, a number of you have called me to discuss what you can do and cannot do as a hearing officer to address matters that are not clearly spelled out in either federal or state law. You're not alone. We get these types of questions all the time from hearing officers in other jurisdictions, as well as administrative law judges who preside over these cases in other jurisdictions where they have an OAH. These OSEP letters are nice to have in your back pocket when you're grappling with issues regarding your discretionary authority. Lynn and I consistently cite to them when there are issues regarding what can we do if the state law is silent, if IDEA is silent, and I have to figure out how to make sure that this process is working effectively, efficiently, and on a timely basis. OSEP has said you have expansive discretionary authority. And when you want to support whatever decision determination you've made to make sure the process is working the way it needs, some of these letters are letters that you can cite to with respect to your expansive authority. Any of you on the panel ever cite to OSEP letters or comments for the proposition of your expansive discretionary authority?
I would not. No, I think it is very much implied that unless the statute or the regulations dictate certain decisions, that is, inherent in the role of a hearing officer. And we were guided by fundamental due process, so I don't think I have to cite anything to support the fact that I have broad discretion. Yeah. As long as
Karen, while I totally agree with you on that, the problem is sometimes we have to educate eventually the courts, as to our authority because they may not know anything about the special ed law. So I don't think it hurt, even though I agree you're right, to cite this type of authority and in support of your discretionary authority. We have a question here that's I think is very
and while we, one second, Lynn, and Karen, I also agree, and I also think you also have a number of court decisions that talk about the your authority being coextensive with that of the courts, and that's a quote, right? So but why I'm raising this is because time and time again, and again, I'm not saying this is only a problem in New York or something that only happens in New York. It happens everywhere. You will have a discussion with we'll feel the call from a hearing officer, and we would suggest, why don't you do this? And the first comment back is, oh, I can do that. So as we get comfortable with our role as hearing officers, and there are a number of hearing officers in tonight's webinar that are newer than most, we are making sure that you feel empowered to do what is right so long as it's consistent with due process and the IDEA. Go ahead, Lynn.
The question is, would you put the analysis of comments and changes to proposed federal regulations that appear in the Federal Register in the same category as the policy letters and the Dear Colleague letters?
This is Karen. I would not, and that's why I'm saying I would not defer to the letter of anonymous. If there's a dispute over some procedural issue that I need to decide, I would simply explain it in the context of relevant law and regulation and the basis for exerting my discretion to do X over Y. And I would give that explanation, and if it's based on solid reasoning, I think that's good. I think we tend to waste our time, I'm sorry, looking at these letters when, it's really based on the reasoning, not the fact that I have discretion. It's how I exert the discretion. And that's what I have.
Can I just endorse what Karen said? Because, I've done hearings in other city and state agencies, and special education is the most regulated practice there is when it comes to these administrative hearings. And it's interesting that because it's so regulated, it seems that people are looking for what their authority is in any place where the regulation doesn't address it. But in fact, in other kinds of hearings, what I'm relying on basically is my authority under the 14th Amendment and due process to make sure that standard legal practice basically says that what the parties are entitled to is notice and an opportunity to be heard. So that I'm not sure you need to get into the weeds on this kind of level in terms of just saying that you have the authority, as long as you have common sense and you have, basically you articulate what the reasoning is for your decision.
And I would generally agree with you guys, but I can tell you from experience and having trained hundreds of hearing officers across the country that your thinking is not always adopted by those who are sitting in your shoes. That they feel that they need a black and white rule or something that's in the regulation that says, I can do this. Some of your colleagues have called me saying, can I do this? And yes, you do have inherent authority. As to the question that Lynn, you asked, I think it depends on the circumstances. I do believe that sometimes the analysis that are included in the comments may be useful to cite to in support of whatever it is that you've decided. You might adopt the rationalization that is included in those comments and then cite to it as support for the proposition or your decision, etc.
Giuseppe, I guess we're being trained, and I think that Nancy's comment is so important that all hearing officers not only understand the broad discretion that they have, but the basis upon where it derives from, and that should be key in in any decision that you make regarding procedure, I think here there's one, and I think it's a great example, the one about telephonic testimony, for example. So our regulations, federal regulations say you may, but to simply say because it says I may without thinking of the number of issues involved and giving the reasoning for your decision, it's really an oversimplification. So I think we have to keep in mind exactly what the considerations are, and that should guide our decision, except where there is a very clear and unequivocal rule that says you shall, you must.
There's a comment.
I partially agree with you, Karen, but again, unlike some other agencies where there's clearly spelled out powers and responsibilities and duties of the hearing officer, we don't have that in IDEA. In fact, the word hearing officer only shows up couple of times in the regulations and doesn't really define what the role of the hearing officer is. So I hear you, but I don't entirely endorse what you're saying. But I agree that there's inherent authority of a hearing officer. And for those of you who might be in the fence as to, can I do this? And you're not accepting the fact that inherently I can do this in terms of the role that I am playing, we're providing you with support to do so. Go ahead, Lynn, and then I have to move on.
There's a comment. The commenter says, Nancy is right. These types of letters are more of an advocate's tool to be used in persuading the hearing officer as to how he or she should exercise his or her discretion.
Okay, I'm not sure I would agree with that, but
I'm not sure I would either.
Okay, let's go to page 6. Letter to Wild makes clear that a hearing officer, not an SEA, state educational agency, or LEA, determines whether an issue is within his or her jurisdiction or whether a party has been properly named in any hearing request. Letter to Insalbach. OSEP was asked, and that's subparagraph 2B there in the middle of the page, was asked, what options does a parent have when a school district does not provide a written response to the complaint and has not previously provided prior written notice? For those of you who might be foggy on this, remember, a written response is required within 10 calendar days of the due process complaint having been filed, unless, of course, the school district has issued prior written notice on the issues that are raised in the due process complaint. In letter to Inselbuck, without defining the options that are available to the hearing officer, OSEP does say that the hearing officer can address the failure if it is not resolved by the parties themselves. Letter to Moody at the bottom of the page, subparagraph C, addresses the question of which state has responsibility for a student when the parents move out of the state in which the student is attending school. As you know, the new home state assumes responsibility to provide special education to the student. This issue of residency, and why I'm highlighting it, is because it comes up from time to time, and you as the hearing officer have the authority to make residency determinations. And if it does come up as an issue in the case, it needs to be decided promptly, perhaps with a limited hearing to address some of the factual issues that you need to determine before you can decide the specific question. On page 7, we have a letter to Cox and Ward. It reminds us that our hands are going to be very much tied when you have disagreeing parents who both have educational decision-making authority. Cox and reaffirmed in Ward says that the hearing officer does not have jurisdiction to address disputes between parents and that such disputes are a state or local law matter. As you can imagine, and some of you might have presided over such a case, if one parent is consenting to services and the other is revoking consent, that puts a lot of people in a pickle. But there's not much we can do. If it does come up in one of your cases, you may be in a situation where everyone involved, both sets of parents and school district, may need to weigh in order to decide how to proceed with the due process complaint. A bit more nuanced is where you have divorcing parents who share educational decision-making authority and who agree that the complaint should go forward, but not necessarily in how to prosecute the complaint, and each wants his or her lawyer involved in the case. In this latter example, this is where letter to anonymous that we had just been talking about can be helpful to you, because you can be called upon, and you might need to get creative on how to manage those complexities, the complexities that arise between these divorcing parents, in making sure that the hearing moves forward. IDEA doesn't give you a script on how to handle divorcing parents who share educational decision-making authority.
Dave Steady?
Yep.
I've had at least a half dozen hearings where there were divorced parents with joint decision-making in the educational arena, and one of them agreed with the district and sat with the district, and the other one sat on the other side of the room and had their own lawyer, and they were fighting the IEP. And so I find this letter to Cox and to Ward a little bit troubling as a practical matter, because I'd like to ask the panelists, have you ever had that kind of a situation play out in New York State? Take it not.
Yeah, but I mean, you're essentially in a pickle in those cases. But again, I think if we go back to what Nancy was talking about, just inherent authority, we go back, if we rely on like the rationale of letter to anonymous and everything else that OSIP says, I think you can be creative in how you address those issues in a case like that. Letter to Ramirez, which is at the subparagraph E on page 7, caught many people by surprise when it was published back in 2012. The general consensus prior to the letter amongst hearing officers, school districts, and parents prior to this letter being published was that the IDEA hearing officer does not determine whether certain action by a student with a disability amounts to a violation of the school district's code of conduct. That typically is the function, as you probably know, of a disciplinary hearing officer, which is not the same as an IDEA hearing officer. Ramirez says, no, an IDEA hearing officer has the discretion to determine whether the student's behavior, in fact, violated the school code of conduct in some instances. For example, under 34 CFR 300.532, a school district may petition you, the IDEA hearing officer, to remove the student from his or her current placement to an IAES, interim alternative educational setting, for up to 45 school days if the student violates a code of conduct and his or her continued placement in the current placement is substantially likely to result in injury to the student or to others. It would seem reasonable under those facts that the hearing officer may need to address whether a violation of the code of conduct has occurred that warrants removal to the IAES. Any thoughts on Ramirez from the panel? Has that come up with you where you have been asked to determine whether in fact whether in fact the student did violate the code of conduct? As an IDEA hearing officer, not a disciplinary hearing officer. Not having anything, I'll move on.
It's never.
Go ahead.
Before you go, there is one hearing officer who had a situation like I alluded to, where you had one parent sitting with the district and another one opposing the IEP, and he or she held the hearing and decided the matter. Then there is another person who raises the question, when you have the two fighting parents, would that be a situation where you could appoint a guardian ad litem in the state of New York?
It depends on the You have to, as you know, you have to determine in New York whether the interest of the parents are opposed to the student. If that threshold issue is not, if that doesn't exist, then there wouldn't be a basis for a guardian ad litem. The fact that the two parents are not necessarily seeing eye to eye doesn't necessarily mean that they don't have the interest of the student at heart. So I think it all depends on the facts and circumstances of the case.
And while I've interrupted you, another person makes a comment relying upon the Chevron doctrine that the agency's interpretation of the statute is supposed to be deferred to unless it is unreasonable. And the point is made that these are somewhat stronger than merely persuasive authority. They are authoritative, subject to counter-argument and defeasance.
Yeah, I mean, you could argue this, but I generally agree with the commenter. But there are interpretive rules, and for some reason there is some general hesitation to rely on OSEP letters. And there are other agencies that put out bulletins. The tax department, IRS, puts out bulletins, and the stakeholders who appear before that agency and anyone who relies on those bulletins really take it to heart. That's their interpretation. The courts rely on it. Perhaps we don't see a lot of courts in the IDEA world citing to OSEP opinions, but they do exist. And I do cite to one in the outline coming out of the Second Circuit. There are out there, and they will turn to OSEP on matters that are gray, that are not specifically addressed in IDEA and the regs.
I think what's really important, though, is that under IDEA, as opposed to statutory authority granted to agencies to interpret regulation, was the very very direct congressional edict that said in the last amendments that the agency could not promulgate any kind of policy or interpretation of regulations without going through the comment period. I'm not aware of any other congressional mandate given to an agency other than that one. And that's very powerful, which is one of the reasons, of course, that the agency, the U.S. Department of Education, through all these letters and policy letters, have to give, a disclosure saying that it cannot be relied on unless in those very rare cases it's actually going through the comment and regulatory process. So this seems to kind of stand alone, and that's why I question at least the authority of these letters in view of congressional intent.
Karen, you are one of the few, other than law review writers, who gives much credence to that little fight between Congress and OSEP.
Well, I think it's pretty powerful stuff, and actually, for those of us who have been around for a while, I think we're familiar with the history. But that's the statute. I mean, that is a statute. I don't think it can be ignored. It is the law, and OSEP defers to it, in a little footnote anyway.
Well, they have no obligation. They have an obligation to refer to it, to footnote it in their letters, because it's in the law to do so. But again, courts rely on it, Karen. So if the courts are looking at it when it's appropriate, then why wouldn't it be also appropriate for the hearing officer to rely on those letters when it's appropriate and when IDEA does not fill in the gaps?
Well, I think the question is how the courts rely on it. There's not a problem if the courts refer to it, see it as persuasive and consistent with statutory and regulatory authority, but they're not simply citing it to say, this is the basis of my decision, like you would cite a U.S. Supreme Court decision or a Second Circuit decision. If they are, then I would say they're mistaken, and no one had argued that, they should not be relying on these policy letters.
Okay. and as I said earlier, you do have to determine whether they're persuasive. You have to talk about the extent that they put into it, and if they're persuasive, then you can rely on the rationale of it and cite to them to justify your the basis of your decision. I'm going to move on. Letter to Lipset on page 8 reminds us that a parent, and this I believe is the letter that Michael was referring to earlier, that a parent may challenge an IEP that he or she has previously agreed to or that has expired, provided it is within the challenge is brought within the 2-year statute of limitations. However, there may be circumstances when the parent's delay in filing the complaint may be a factor in fashioning equitable relief when warranted. So the fact that they are able to, there may be an instance where you have a parent who has agreed and said everything is going dandy for a year, and they don't file until right before the statute of limitation is about to expire. Can you take into consideration the parent's behavior throughout that year that the IEP was in place in fashioning your equitable relief? Absolutely. In the state of New York, where there are many private settlement agreements between the parties, the question of whether the hearing officer can review, approve, or enforce agreements, private settlement agreements, which is to say agreements that are reached outside of the mediation or the resolution process, has come up with some frequency. In Letter to Shaw, which is in subparagraph H on page 8, OSEP says that it is a state matter to decide whether the hearing officer has the authority to review, approve, or enforce private settlement agreements. New York has not promulgated any rules in this regard, which presumably would give each of you the discretion to review or enforce private settlement agreements. But frankly, it is easier said than done. Have any of you in the panel have been asked to enforce or review a private settlement agreement as part of your cases?
Or any settlement
Well, I'm not sure how would one enforce a settlement agreement? I'm not sure I understand how that could be done by a hearing officer. I've certainly been asked to review settlement agreements and possibly so order them.
I'll give you what I think is the most frequent example, and that is where there's a settlement agreement and it resolves a particular issue. Now, let's say the level of speech and language therapy during this present school year, a particular school year. And so the issue again comes up, and the district comes in and says, wait a minute, we entered a settlement agreement, and that issue was disposed of for this year. I think that is probably the most obvious one where you might be called upon to take a look at a settlement agreement.
I've been asked to enforce a settlement agreement in which there was an agreement as to an amount of money that was to be reimbursed, and the check never came, and they're asking me to enforce not only the fact that they pay, but to tack on interest.
And what did you do?
Under that case, and looking at it, and based on the jurisdiction that I was in, I did not enforce the settlement agreement. There was language to suggest that hearing officers in that jurisdiction did not have the authority to enforce settlement agreements. New York, as far as I know, does not have anything one way or the other.
Well, unfortunately, even if we were to seek to enforce it, we have no enforcement power, and that goes back to the lack of contempt, authority to hold a party in contempt, etc. So I'm not sure what the meaning, what the effect would be if somebody asked me to enforce a settlement agreement. What does that really mean?
Yeah.
What authority do I have?
If it's black and white already, right? White, what am I going to do? State it differently? Yeah, clearly, for those of you who are newer to this, in some instances, especially under the mediation and resolution process, settlement agreements would be enforceable under the state complaint process. Were you going to say something, Lynn, before I move on?
Well, I want to go back to Karen's comment. I mean, what can you do? I mean, if you have a settlement agreement that a particular issue was settled for a particular school year, and now that issue is coming before you, I think it could serve as the basis to dismiss that issue. That's probably, I think, the clearest and simplest way that.
I agree on that. Yeah.
Okay. I think that may be the most common way it comes up too, but.
I'm going to put up a. It's time for a code, right, Lynn?
Yep.
I'm putting up code number 3. Code number 3 is up on your screen. Please write it down on your affirmation form. Code number 3.
Well, they're looking at code number 3. Let me ask this question: what if a settlement agreement indicates that in return for real consideration?
We lost you there, Lynn. All right, Lynn, I lost you, so I'm gonna move on. Code number 3 is on the screen. It's now gone. All right, let's go back to.
Can you hear me now?
Yeah.
Okay.
Let me just put this on full screen so you could see it better. So we're on page 9. The next set of letters on page 9 to 10, letter to Fisher, letter to Chassis, and some of the others that are cited therein, letter to Goldstein. We've discussed all these letters in the past, in past trainings. They all have to do with stay put. Letter to Fisher, subparagraph I on page 9. Sets out the 4 factors to determine whether a change in placement has occurred, and it's helpful when you are trying to determine what the stay put should be. Letter to Chassis on page 10, and the others that are cited to in subparagraph J, letter to Heldman, letter to Storer. Just say that the hearing officer can determine the stay put when there is disagreement. Nothing novel in those 3 letters. And finally, letter to Goldstein, subparagraph K, which is specific to New York City, speaks to the practice of requiring a written order of a hearing officer prior to implementing an uncontested stay put placement. Basically, it slaps the school district in the hand and says the school district should not wait for a formal order, but it then goes on to say that if there is any delay, there may be a need for a written order from the hearing officer. So I'm not sure it provided the type of definitive guidance that we would like as hearing officers, but it does tell, and I believe this is the New York City DOE, it does tell the New York City DOE that your practice of requiring a hearing officer order is inconsistent with IDEA when stay put is not in dispute. On page 11, we have dear colleague letter in subparagraph N. Apparently, there is a growing practice by school districts to file due process complaints after parents have filed state complaints. When this happens, it may delay the state complaint resolution process. As you know, IDEA says that a state must set aside any part of the state complaint that is being addressed in the due process hearing until the hearing officer issues a final decision or dismisses the complaint. If the hearing officer issues a decision, then whatever the hearing officer decided on an issue that is also raised in the state complaint is binding on that issue. It appears to OSEP that in some instances, school districts may have filed due process complaints against parents in an effort to prevent the state complaint process from moving forward. Not only does a due process hearing increase the costs for the parents. It's more adversarial, and it can take longer than the complaint process. The complaint process is 60 calendar days from the filing of the complaint. Obviously, it can also be extended, but extensions under the complaint process are fewer than in regular hearings. In addition, it may be unreasonably, removing it from the state complaint process to the hearing process may unreasonably deny a parent the right to use the state complaint process. This practice raises an interesting question. Can a school district file a due process complaint on a matter that it would not have standing to file in the first place? For example, if the school district determined the student ineligible and the parent did nothing, the parent's not challenging the fact that the school district found the student ineligible, would the school district have a basis to file a complaint under those circumstances? It's hard to imagine, at least for me, why the school district would file in the first place, since the parent's not challenging the ineligibility determination. Under those facts, the school district would either not file at all, or if it had filed, would have a difficult time justifying to the hearing officer, at least if I was the hearing officer, why the case should be heard, given that the parent is not challenging the ineligibility determination. So why would it be different when the parent has initiated a state complaint where now the parent is challenging the ineligibility determination? It would seem that the school district is simply attempting to reassign the issue to its preferred forum, which is the due process hearing, rather than staying in the state complaint process. Any thoughts on that from either the panel or Lynn?
I can just note that this has become a huge issue in my state of Michigan, and I know from having heard from others that the Dear Colleague letter was prompted because it is becoming more common in other states. And an ALJ in my state just ruled a couple of days ago that the district could proceed on that hearing, but regrettably her analysis was limited to, is it one of the magic 4 items, identification, evaluation, placement, or FAPE? They never apparently were presented with the issue to rule on, could a district file a request for a due process hearing when it was not aggrieved by the IEP in the first place. They're just doing it to circumvent the parents' avenue of pursuing a state complaint. So the decision in Michigan was a little shallow, I believe, in terms of not getting to the point that Day of Study raised previously. And I would not fall into that trap.
And I would encourage you, because we are hearing of this more and more, I would encourage you to read Dear Colleague letter, because it might be something that you may be presented with, and you should have, excuse me, you should have the questions at hand that you might want to ask of the parties if you were presented with a Dear Colleague situation. The next set of letters on page 12 speak to pre-hearing matters. Letter to Reisman speaks to maintaining the confidentiality of personally identifiable information and the hearing officer's role in doing so. Another letter to Anonymous makes clear, and let me just make sure I didn't, I'm on the right page 13. OSIP makes clear that hearing officers cannot override the parental consent requirement necessary to disclose a student's educational record to a third party. Here, a parent requested copies of disciplinary records of 2 students who were the subject of the same disciplinary event, one of the students being the parent's child. The hearing officer ordered the school district to disclose the disciplinary records, even though the parent of the other student did not agree to the disclosure. OSIP determined that compliance with the order would violate FERPA. The letter does not say how the school district should resolve the catch-22 it finds itself in. Ignore a hearing officer's order, direct order, or deal with a FERPA violation. OSIP just kind of punts on that. Regardless, this letter does have some practical application that goes beyond the limited question that OSEP answered, and I like to talk about that just for a few minutes. In some cases, council will ask you to compel the production of IEPs, class profiles, or other similar information. Though often these documents are redacted when they're produced, these documents may nonetheless disclose personally identifiable information of a group of students to a third party, the other, the parent, the hearing officer, because you wouldn't be privy to this information because they're not; these other students are not the subject of the due process hearing. So keep in mind that personally identifiable information is defined to include, and I am quoting from FERPA, other information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. It also includes a list of personal characteristics. An IEP, a class profile, even when the names are redacted, may nonetheless include information or personal characteristics that may be linked or is linkable to a specific student. So when you are presented with a subpoena for documents requesting a class profile or copies of the IEPs, whether to challenge the appropriateness of the placement, whether to the parent might want to be demonstrating that at least under New York law, the student is not functionally grouped, that may have some FERPA implications. Page 14, letter to mamas, subparagraph C, tells us that there's no general entitlement to observing the student in any current classroom or proposed educational placement. This is one of the letters that I think Michael also was alluding to earlier in our discussion. However, there may be circumstances like when a parent is looking to exercise their due process rights, like obtaining an independent educational evaluation (IEE), when access may need to be provided to the independent evaluator. Interestingly, OSEP uses the IEE as its example as to when there may be a need to allow access to the classroom to allow for an observation. The IEE, in my mind, is the most obvious example of when access may be absolutely necessary to allow the parent to exercise a right under the IDEA. But are there other circumstances? Would you find plausible if the parent would argue that their ability to present his or her case would be stymied if his or her expert was not given an opportunity to observe the student prior to testifying at a hearing? Any thoughts on that? Would you extend letter to mamas that only uses the example, I think the easiest example of the IE, would you extend it to some of the other rights that are included under 300.512 of the regs?
Well, it would depend on the facts, wouldn't it? You know, the specific facts in terms of what the parent was seeking, you know, why they were seeking an expert, what it was they were looking for in terms of the observation. I really think it would depend specifically on the facts of the case in that matter.
Yeah, I would agree.
Let me just point out it's not a one-way street either, because I had several ABA cases where the parent was seeking reimbursement for ABA in the home, and the district wanted to observe it being done in the home, and they had their own. I mean, this was a battle of experts with regard to ABA or TEACH and other things. And I ordered, the same as I had done in order to assure that the parent had an ability to access the district's program with an expert, I ordered under controlled conditions that a district expert could go into the home and observe the ABA program in the home that the parent was seeking reimbursement for. So I think it can go both ways.
Eddie, can I just make a comment on the FERPA letter that you were discussing before? I would just like to say that I never, ever, ever ordered the production of IEPs of other students in the class, because I think they're incredibly no matter how much you redact, they're still very identifiable in terms of the children. And in terms of class profiles, while I will sign a subpoena for a class profile that's redacted, I also, on any subpoena, specifically provide that documents do not have to be created to comply with a subpoena. It's only if they
That's a
already
good point.
exist.
Michael?
I wanted to add something on letter to mamas. I mean, I'm not comfortable with letter to mamas, even though I've always applied it. I mean, to me, it's not fair for parents not to have an opportunity to observe if they want. But that was the rule, and I went along with it. And yet, I'm not specifically sure about the site, but I'm pretty sure that there has been a case or two recently in the Southern District where a federal judge has relied on the parent's inability to observe the classroom in finding a FAPE violation in a tuition reimbursement case. So I'm not sure how that interplays with letter to mamas, but that's something, I don't know whether you guys have found that case, or Perry's or Kell has found it. But I think it's Judge Forrest who issued that decision. But that's something to think about.
And and I don't. And again, I'm not familiar with the case, but I could ask Perry for it if we have it. If he's familiar with it, I can share it with the cadre through the listserv. And I would want to know the rationale for that. It may very well be that this is a question regarding the parent's ability to make an informed decision regarding the placement before he or she signs off on the services or the IEP. It may be in the context of a reimbursement case, etc. I don't know, but it's worth a look-see, and we'll see if we can identify it. I'm going to continue. Letter to Savitt again continues on IEs, but it stands for the proposition generally that the school district cannot adopt different standards or restrictions for the parents evaluators than what it does for its own personnel. So if the school district's personnel can observe a child for whatever period of time they deem appropriate, you can't now say that you have a policy that the outside evaluator can only observe the child for 1 hour of the school day. A letter to Simberlin on page 15, subparagraph E on the top there. And the others that are their lens and Dawalibi, I think that's how I'd say it, Dawalibi, say that the parent need not raise an issue at an IP meeting first before filing a claim about it. Obviously, that had been an issue in the early 2000s, but there's no need for the parent to first speak up at the IP meeting before they can file a claim on an issue that was not discussed or addressed in the IP meeting. The second letter to Anonymous on page 15, subparagraph G, speaks to the school district having to respond to an IE without any undue delay. When the parent requests an IE, the school district is obligated, according to OSEP, to respond to that request by either denying it or filing a due process complaint to demonstrate that its evaluation is appropriate without any quote undue delay. Unfortunately, OSEP does not define for us what would be an undue delay that's open to interpretation. OSEP also, in this letter to Anonymous, notes that the fact that a parent obtained an IE without first notifying the school district does not relieve the school district of the requirement to seek a hearing if it wishes to demonstrate that its evaluation is appropriate and therefore that the parent should be denied reimbursement. As we've discussed also in the past, letter to Kerr at the bottom of the page, subparagraph H, and Kane on page 16 speaks to hearing officers having discretion to set the number of days for a hearing, subject to state regulations or procedures. As you know, New York does have a reg that affords each side at least 1 day of hearing. The second letter, letter to Kerr also affirms, as you can see on the top there of page 16, that we as hearing officers cannot unilaterally extend the 45-day timeline nor encourage either party to request an extension. This said, this does not mean that you as the hearing officer is prohibited from offering the parties options to weigh in order to accommodate a request of the parties that may lead either or both to request an extension. An example of this would be when the parties would like to submit post-hearing briefs and you agree that the post-hearing briefs would be of some value to you, but there's just not enough time on the timeline left to allow for the briefs and provide you with a reasonable number of days to render his or her decision. Under those circumstances, you may discuss with the parties that there are options. One is, we can do closing statements on the record, and we'll conclude the hearing today, and I will render my decision within the timeline that I have left. Or if you wish to write some closing briefs, I only have, let's say, 10 days left on the timeline. I can only give you 2 days, so I can at least have 8 days to write my decision. Under those circumstances, you could, the parties might come and say, yeah, we'll pick A, we'll do closing statements, we'll pick B, we'll do it in 2 days. Or hearing officer, we would like to propose C. We would like to request an extension of the timeline in order to give us some more time to include the closing statements and give us and then give you some time to render your decision. That's allowed, and letter to Kerr does not disallow that practice. Letter to Stadler on page 17, subparagraph J, addresses the thorny issue of discovery. OSEP says it's permissible and subject to the discretion of the hearing officer, subject to state or local rules or procedures. As you know, New York neither endorses nor restricts a discovery, but we would caution you that allowing discovery may make the process needlessly complex, costly, and lengthy. Letter to Worthington, subparagraph K, reminds us that the 45-day timeline does not magically go away at the end of the 30-day resolution period, even though the parties did absolutely nothing during the 30 days. They did not waive the resolution meeting. They did not meet. They didn't ask to mediate. They did absolutely nothing. OSEP says, once that 30-day period is over, the 45-day timeline begins. You better appoint a hearing officer. If you haven't done so, SEA, New York, they appoint them as soon as the due process complaint comes in. And hearing officer, you are obligated to start processing the complaint and start the hearing process as soon on day 31, essentially. Letter to Bell at the bottom of the page is the one I was talking to, is the oldest case I cite to in this outline, 1979. Give me a second. I'm getting over a code and I just need a little water.
Now's a good time for maybe the next code.
Okay. Code number 4 is up on your screen. Code number 4 is on the screen. I'll leave it there for a couple of seconds. Going once, Gone. So letter to Bell at the bottom of page 17, subparagraph L, stands for the simple proposition that the 5 business day disclosures must also include the names of witnesses and the general thrust of their testimony. Given the limited discovery expressly permissible under the IDEA, ensuring that the disclosures also include the general thrust of the witness's testimony is essential. By the way, as you know, Nancy, this is an example of a case, a letter that's been around since 1979. But I can tell you that into the 90s and even into the 2000s, there are hearing officers out there who are not aware that the 300.512 in terms of disclosure would include the witnesses' names and the general thrust of their testimony.
What's the practice in New York, Dennis?
Go ahead.
When I have a pre-hearing conference, I ask the parties. This is both in New York City and outside of New York City. I ask the parties. I go over who the witnesses are going to be. Now, sometimes they don't know the names of the witnesses,
right,
but they still know the function of the position of the witnesses,
sure,
and generally what their testimony will be about. And I do that to some degree to limit, an outpouring of witnesses that will just exhaust.
Sure. Sure. Good practice.
Just if I could just add on that, I mean, to be honest, the reality in New York State is that it's not done. Witness disclosure is generally not done, certainly not in the 5-day disclosure, and I've never seen a general thrust.
Yeah. Yeah. And frankly, I'm surprised that the other party, whether it's the school district or the parent, has never challenged that. It's clear. I think it's clear in the regulations itself. I think the letter to Bell makes it crystal clear as the billboard, but it's crystal clear to me in the regulations itself. It says any evidence, and evidence would include witness testimony and the general thrust of their testimony.
I've had people challenge the fact that witnesses were not being provided, that they hadn't gotten a list of witnesses.
Yeah.
I guess I want to know, as the hearing officer, and it would be a question to discuss at the pre-hearing conference, who both parties plan to call, and what the relevant testimony, what their testimony will be generally, because I want to avoid duplication. So I would not necessarily rely on the regulation, which speaks more to documents, but I would require it as, as part of that process to streamline the hearing.
I would agree with you in terms of good practice, Karen. I would disagree with you in terms of what the regulations say. The regulation speaks to any evidence. Evidence is not limited to documents. Evidence includes witnesses who are going to be testifying. Testimony is evidence. So I would disagree with you on that. But it's good practice, and I agree. You know me, I speak about pre-hearing conferences in every opportunity I can. You probably are tired of hearing from me about pre-hearing conferences. But pre-hearing conferences is a start. But that said, the parties are not necessarily bound by what they share at the pre-hearing conference. They're just starting, and the 5-day disclosure deadline, that's the latest point that they can change their mind, or they can add witnesses, right? They might tell you, I'm going to have X, Y, and C during the pre-hearing conference and never talk about A, B, and C. But if they include it in their disclosures, then of course A, B, and C can testify. And that's my point, which is how's a party to prepare for a hearing if they don't know which witnesses are going to be testifying. And I think that's what Letter to Bell drove home in 1979 and needs to be driven home more often. And if what Michael is saying is correct, then it's a practice that needs to be enforced in New York State to the extent that you see appropriate. On page 19,
all right, but go
ahead.
Okay.
Go ahead.
No, I was just going to ask, something comes up in a hearing where you need more information, you need another witness in order to have a complete record, that that would obviate against this, this rule actually.
Well,
Whereas you need a new witness. Yeah.
Yeah, that raises some sticky points. It's not a discussion for today, but it does raise some questions about whether the other party can object to that witness testifying. Letter to Bell, and I think the language in the regulations would suggest that the other party can prohibit the introduction. And in my mind, under 300.512, the party, not the hearing officer, has the discretion. The party owns that right to prohibit the introduction of any evidence that has not been disclosed within the 5 business days.
Okay, for another day. But I would disagree with that vehemently.
Yeah, no, I think it creates. I think this is one of those areas in IDA, Nancy, where I can tell you what I believe the IDA says. I can tell you how OSIP has looked at it, whether it's right or wrong. I have opinions about that.
Well, you folks, there's one big exception of this, and that is if the situation just alluded to could be characterized as rebuttal testimony by way of surprise, the hearing officer clearly, in my view, has discretion to allow that if the surprise is honest. And that may allow for a witness who wasn't on the list to come in, I think.
Yeah, and I think, Lynn, I think that's something that's how we rational people, us hearing officers like Nancy who are struggling with this, can rationalize getting around this kind of rigid rule in terms of the rights of the parties under 300.512. Yeah, how can you anticipate rebuttal testimony? You can't. You can't. So that's one way of, and this is where you go back to like letter to anonymous and all the inherent authority of hearing officers to kind of slide that in and say, come on, if I'm going to make this process fair, if I'm going to allow for some basic due process, I'm going to allow for rebuttal testimony. But if you read it strictly, if you're a strict constructionist, you can argue that that wouldn't be allowed. On page 19, letter to IHG, OSEP reminds school districts that they must exercise some flexibility in allowing parents to participate in resolution meetings in ways other than being physically present. It would be appropriate under the circumstances as hearing officers, and given this letter, for you to consider the reasons for the parents' request to participate in the resolution meeting by telephone or perhaps by video conferencing when you're considering a request for dismissal by the school district because of the parents' failure to participate in the resolution meeting. That concludes the letters that we thought were relevant to your work in pre-hearing matters. We have a number of letters regarding hearing matters. Letter to Stadler, subparagraph 4A on page 19, simply says that a school district can share personally identifiable information with the hearing officer about the student who is the subject of the hearing without first obtaining consent from the parent. No, we don't need consent. If you file a due process complaint, parent, we don't need consent from you to then share with the hearing officer the due process complaint or our disclosures. Letter to I.M. Obersteg. It's actually an R, not an N, but I left it as it is published by OSEP. But letter to I.M. Obersteg says IDA testimony need not be sworn. It's a matter left to the discretion to the states. Interestingly, and I went back to look at this when I was preparing for the webinar, though New York State authorizes hearing officers to administer oaths, it does not expressly require sworn testimony. This raises an interesting question. What if we forget to swear in a witness and the record is closed? Can we rely on the testimony? I'll give each of you a quick shot at it. I want to make sure I have enough time to finish the outline. On Nancy, Michael, or Karen, what would you do under those circumstances? You have you forgot to swear in a witness. The record is now closed. Would you rely on that testimony? How would you handle it? New York doesn't expressly say you have to take sworn testimony. It says you have the authority to administer oaths.
I would say, now that I know, about this OSIP, I would say, do you swear everything that you've previously stated is true to the best of your, is the truth, or something to that effect?
So, I mean, you would, that's if you're at the hearing. What happens if the record is closed? You're now sitting, you're back home and you're reading the transcript. You're like, uh-oh.
I'd reopen it.
I don't think
I
it.
would,
Yeah.
I would
And
reopen
that may be a circumstance if you have time. That may be a circumstance, as we spoke, I think, a couple of webinars ago, in terms of, is this justifiable? Is there good cause to open the record to allow for me to go back and make sure that this witness adopts the testimony as being true and accurate? Karen, Nancy?
I don't know, perhaps you could get affidavits from I mean, it depends how many people you're talking about. You're talking about one witness or several witnesses.
Yeah.
Did you go through a whole hearing absolutely missing this? That would be a little frightening.
So, and again, I raise it because New York doesn't expressly say you have to take sworn testimony.
I would require an affidavit to include a statement that it's truth and that it's a statement of truth subject to, penalty or et cetera. I would not accept one that does not provide that statement, and I would give them the exact statement that I would want. But otherwise, I think in New York, it's really a matter of practice that everyone is sworn in. And if someone objected to being sworn in, I would not take their testimony.
Oh, I once had a person in another agency, a person who was a Moor, M-O-O-R, state that he could not swear or affirm his testimony. And I said I wouldn't allow his testimony if he couldn't do either. So.
I think another option, this is Lynn, another option would be to allow it, but say that the fact that it wasn't sworn would be a factor in considering its weight or credibility. Because when you don't allow the testimony,
Nancy, would you ask, like you might deal with a child? Would you ask, are you willing to tell the truth?
Are you asking me that question?
Yeah.
Oh no. Well, he gave in and he was affirmed in terms of his testimony.
Okay.
Well, I've done hearings. There are other agencies that don't require testimony to be sworn in some kinds of hearings, and I've had hearings like that where people are not sworn in for their testimony and use them for decisions.
Okay.
Special ed hearings.
I'm going to move on because I want to make sure I cover the materials. Letter to Stanky on page 20 is one of those letters that gets us out of a bind, but its reasoning is questionable. This is like what we were just talking about in terms of getting around the disclosure rule with rebuttal testimony. OSIP extends the disclosure period for additional evidence to any time during the hearing process, provided the disclosure of the additional evidence is disclosed 5 business days before the next hearing day, and the hearing officer didn't tack on an additional hearing day simply to satisfy the disclosure rule. Fundamentally, this alleviates the hearing officer's lack of authority to overrule a party's objection to allow into the record evidence the record evidence that was not timely disclosed. However, it raises an issue of fairness. For example, if the other party will not have an adequate opportunity to respond to the impact the additional evidence would have on the evidence that has already been presented, there may be justifiable reason not to permit it, even though technically the 5 business day rule is met or can be met. On the other hand, if the additional evidence is evidence that had been withheld by the other party despite it being requested prior to the commencement of the hearing, perhaps during the pre-hearing conference, there was a discussion of this additional evidence or these additional documents that they wanted, and they didn't surface until after the 5-day disclosure deadline. Perhaps this was a subpoena that you signed and they weren't produced, etc. It may very well be appropriate to allow this additional evidence in a subsequent day of hearing, so long as the 5-day rule is met. Again, this is one of those letters that just doesn't seem right from a fairness, but you can use to your advantage in terms of justifying why you might depart from the general practice that you have. That the 5 business day disclosures is counted from the first day of hearing, not any subsequent day of hearings in that case. Pages 21, 22, and 23, there are a number of letters regarding the decision. So I'm just going to review some of those. Letter to Colli, Wiener makes clear that the hearing officer, and that's subparagraph C down here, cannot reconsider his or her decision once a final decision has been issued. Corrections for typographical errors are permissible as suggested on page 22 in subparagraph E, right here under the analysis and comments that I list here. Again, from 1999, here's an example where that's still good. OSEP still follows what they said back in 1999, which is you can make typographical changes to your decision once the decision is published. If you do something like that, however, I would remind you to make sure and make clear to the parties that the timeline to appeal the decision remains unchanged. Letter to Anderson, subparagraph F. OSEP continues to emphasize the importance of confidentiality. The written decision must be the written decision prior to being made public has to be free of any personal characteristics or other information that would make it possible to identify the student. When redacting, you should consider the size of the school district, the school and grade, the prevalence and knowledge of the student's personal characteristics, and other information within the community when deciding what and how much to redact from the written decision. SCD, as you know, just issued, and if you don't know, you should look for it. It's in your inbox. A revised redaction policy just yesterday. We would encourage you in terms of just making this easier for you to use generic identifiers in the body of the decision and consider the use of an appendix in which you list the specific names, etc. Even under that practice, it may be necessary to further redact additional information where, for example, you have a student with a low incidence disability. Letter to Anonymous on page 23, subparagraph G, is a response to the New York practice of redacting the names of hearing officers in districts and case numbers from written decisions. Generally, OSEP told New York that this information should not be redacted. And from my quick review of the revised policy that you received in your inbox yesterday, it seems that New York has conformed its policy to be consistent with Letter to Anonymous on page 23. Oh, I went up. Letter to Khan on page 23. Yep, subparagraph B. Tells us that our remedial authority is quite extensive. However, this does not mean that we can willy-nilly award whatever comes to mind. The remedy must fit the scope of the violation, be supported by the record, and consistent with the IDEA. Letter to Armstrong at the bottom of page 23 tells us that the hearing officers have the authority to impose financial or other penalties on a school district and to issue an order to the SEA. Again, a nice letter to have in your back pocket if that ever comes up. I cite to this and other letters and court decisions in my outline on the sanctioning authority of hearing officers, a topic that we discussed a number of years ago in I may have been in a webinar. Letter to IG on page 24, subparagraph E, speaks to the authority of a hearing officer to accept or reject the school district's proposed placement. I guess in 1980, when this letter was written, this was a remarkable proposition. However, I highlight it to drive one point home. The hearing officer's authority to accept or reject the proposed placement would also apply to the parent's proposed placement, meaning that the hearing officer can order an appropriate placement that neither the school district nor the parent has proposed, provided the hearing officer has the record evidence to support his or her determination and has further determined that the school district's placement denies the student FAPE. I'll leave
Stay
it to,
steady.
yeah.
Stay steady. A question on this, because this goes back to 1980, this letter. In this letter, does the word placement actually mean program?
I would have to go back, but I don't believe. And Lynn,
In other words, I don't think it's bricks and mortar. I think it probably is just the program proposal.
I believe placement means the continuum of options, not a specific site. But but that doesn't change my analysis, which is you as a hearing officer on both sides, school district or parent, you don't have to accept what's put on the table. So long as you have a record, you could define what is an appropriate placement based on the evidence that has been presented.
Agreed.
I'll leave it to you to read the miscellaneous cases, letters, I should say, on page 25. They are tangentially related to your work. Let's look at some substantive law. Just give me one quick second. I need to just turn on the lights in my office. It's getting kind of dim in my office. Hold on. Sorry about that. I thought the sun would stay up a little longer than I imagined. But letter to Champaign, which is on, where am I? Did I miss it here? Yeah, 25. Thanks. Letter to Champaign, OSEP reminds us that once a student has been determined eligible and has not exited special education, a new LEA, whether in the same state or a different state, is not required to obtain consent in order to continue to provide FAPE to the student. Consent would be required if the LEA decides that an evaluation is needed to determine whether the student continues to be eligible or is eligible. There are a number of IEEs starting on page 26. Most of these letters affirm the school districts that school districts cannot adopt policies that treat independent evaluators differently to its own evaluators. Noteworthy is letter to Pesca, a subparagraph B, affirms a school district's obligation to reimburse reasonable travel costs or other related services incurred by a parent in connection with an IE. So if the parent has to travel, whether it's within the state, some distance, or out of the state for an IE that this district has agreed to, the parent would be entitled to reasonable reimbursement of those costs. Letter to Faustini on page 27, sounds like a magic act, right? Tells us that an IP team does not need to list the recommendations that were adopted during the meeting. That's the purpose of the prior written notice. Letter to Anonymous, subparagraph E, is again a response to an inquiry coming from someone in New York. The question posed to OSEP is whether the practice of requiring a prescription from a medical doctor prior to providing a related service is consistent with IDEA. OSEP says yes. provided there is no cost to the parent. Keep in mind the F in free appropriate public education, and there's no delay in providing the service. Presumably, if the delay is unreasonable, OSEP would find, and by extension, I would say you can find, that the school district was required to provide the related service even though the requirement for a prescription was not met. There are a considerable number of letters regarding IEPs and placements. I talked about Appendix A from 1998, again, with the reminder that you might need to cross-check with the 2006 comments to make sure their thinking, OSEP's thinking, has not changed. Letter to Anonymous, subparagraph B, makes clear that draft IEPs are permissible practice. Provided everyone in the around the table, including the parent, has a bona fide opportunity to discuss the draft and to participate in the final product. Letter to Thomas at the bottom of the page reminds school districts to be flexible in scheduling IEP meetings, but does not find a school district's practice to generally schedule the meeting during regular school or business hours to be unreasonable. Letter to Anonymous, lots of letters to Anonymous, right? On the top of page 29, subparagraph E, gives school districts the nod in implementing policies that disallow the recording of IEP team meetings, provided that exceptions can be made to allow for recordings where they are necessary for the parent to understand the IEP or the process, or to implement other parental rights under the IDEA. If the school district does record the IEP meeting, it does become an educational record subject to FERPA. Middle of the page, that letter to Anonymous. Yeah.
That sometimes we as hearing officers will get a request by a parent to record the hearing, and we have to be careful not to just deny that, contending that it's not the official recording or whatever. And this letter might be used by analogy, and be sure to ask the parent why they are doing it, because they may have a disability of some type, and they're doing it so that they can more fully participate in the hearing process, in which case you very well might want them to be able to make the recording. But I think I would advise them that it's not the official recording. That's done by the court reporter or whatever. But this ruling might be used for that purpose if that request is made of you by a parent.
All right. Letter to Anonymous defines the must consider, what OSEP thinks it means by you must consider the IE. It means that the team has to review and discuss it, but not necessarily adopt its findings or recommendations. Letter to Hayden at the bottom there clarifies that separate annual goals for related services are not required under IDEA, provided that there are other annual goals that address the student's identified needs. Letter to Trader in the middle of the page there. It's a hot topic a number of years back, and it's reared its head again recently with the FDA indicating that it intends to ban electrical stimulation devices used in aversive therapy. OSEP tells us that IDEA does not prohibit aversive therapy, but individual states can. OSEP does remind us that IP teams must use positive behavioral interventions. New York State, as you know, has prohibited aversive therapy, but allows for a child-specific exception, but that exception is limited to students whose IP included the aversive therapy as of June 30th of 2009. Once it's off that student's IEP, the aversive therapy cannot be put back on the IEP. Letter to Hufner tells us BIPs are not a requirement of an IEP. An IEP team can include a behavior intervention plan, but it's not a required component of an IEP. letter to Anonymous at the bottom of page 31 speaks to methodology. Again, it reaffirms the longstanding position that it is within the discretion of the IEP team to determine whether a specific methodology should be included in the IEP. Letter to Anonymous on page 32. I believe that, yeah, N. Again, specific to New York, the question is, can the state allow the Board of Education to approve a student's IP? The answer is yes, provided the board is not permitted to unilaterally change the IP and or placement. The board, however, can require the IP to consider its concerns. Letter to Bacchus at the top of the page tells us that the school district is not required to purchase personal devices like eyeglasses or a hearing aid, unless, of course, they're necessary for the child to receive a free and appropriate public education. And if they put it on the IP, the school district is obligated to purchase it. But if it's something that it's not on the IP and it's something that the child needs, whether in school or not, it's not required to be purchased by the school district. Letter to Esteban tells us that the student doesn't have to first fail before he or she must be moved to a more restrictive setting. Almost done, guys. Just a couple of more. Letter to Goldman at the bottom of page 34 stands for the proposition that a student who is withdrawn from a school for whatever reason and for any length of time does not lose his or her eligibility status even when he or she returns to the public school setting. Upon his return, the school district must continue to provide FAPE unless an exemption applies, like graduating with a regular diploma, aging out, or being determined no longer eligible. But what's important about this case as well is that OSEP confirms that the school district is obligated to conduct a triennial evaluation of an eligible student, even when the student is parentally placed in a private school. There are a number of, starting on page 35, letters regarding discipline, that Q&A, if you want to get the lay of the land and you're not as well versed on disciplinary process and procedures, that Q&A is a great letter to review. Letter to Cox at the bottom is an important one. It defines a school day for purposes of disciplinary removals. It includes summer school days if both students with and without disabilities attend for instructional purposes, but it does not include ESY days, extended school year days. It had been that that most stakeholders believe that you wouldn't count the summer days because school was out. But if there is summer school and both students with or without disabilities can attend, those days are counted towards the expedited number of days for you to render the decision or to issue your decision.
Dave Steady, could you throw up the code? A couple of people got to leave.
Yep. Finally, the letter to Schneider, which is the last one that I was going to refer to, it speaks to, it affirms that extensions of the hearing or decision timelines in disciplinary cases are not permissible. You can always bifurcate the issues so that you have different tracks. But that's it, guys. Code number 5 is up. Code number 5 is on your screen. I want to thank the panelists, Karen, Nancy, Michael, for your time. This is the end of the webinar series. Our next time together will be in October. Those dates are being finalized. As soon as they're finalized, we will shoot you an email so you can set aside the dates for the on-site Albany and New York City training. Have a wonderful spring. Have a wonderful summer. If you need us, if you need to talk about a case or you're grappling with something, we're here for you. Thank you for your participation tonight, and good night.